It's the Alterations session this week, and basically responding to alteration requests and managing access to common property, common areas for strata lots. Jennifer Neville is a lawyer with Hamilton and Company in New Westminster, so thanks so much for joining us today, Jennifer. That's just wonderful. This week's webinar sponsor is Steadfast Properties, a management and service company. Thanks so much to them for their sponsorship. And just a few little items. We do record these webinars. If you submit a question through the Q&A, we try to group them and put them all together in advance. The other thing is many of the people who attend send us questions in advance, which helps us to stack them and group them all to be able to respond to them at the end of the sessions. Just again, for your own privacy, don't identify your strata plan or business or personal information. And we've included the speaker email addresses if you have any questions as they come up. So Jennifer, when you're all ready, we're ready to launch right in. It's all over to you.
Okay, terrific. Thanks, Tony. First, I wanted to thank CHOA for organizing these Tuesday sessions. It's, I think it's a really innovative way to educate people from the comfort of their own homes, and especially to connect during a pandemic. So thank you. Today is the topic for me is alterations, and this is a topic that I think is really fun. I do a lot of drafting agreements, and in particular, alteration agreements are in quite high demand. So it's something that I enjoy and I'm passionate about. So let's start with the first slide about what you need to know about alteration agreements. You want to consider how the property is designated, the language of the bylaws, who's conducting the alteration, whether an alteration requires building permits, if an alteration consists of a significant change in the use of common property, and we're going to talk about that a little bit more today. If an alteration would result in a significant impact to the use and enjoyment of any other strata lot. You also want to know if there are any conditions that may be imposed by the Strata Corporation prior to granting permission. So one example that I can think of is if a Strata Corporation was going to be granting permission to install speakers on a patio, they may want to limit the days of the hours in the day that people could be using those speakers, and that may be part of a hot tub as well. So you want to be careful about those sorts of things in that scenario. And the last thing you want to know is if the applicant will be held responsible for the costs associated with the alteration. And I don't want to give any spoilers here, but I would say yes, and I'll repeat that throughout this discussion as well. So what are the property designations? And this is the most important consideration when looking at an alteration application. So I'm going to go through I think some probably repeats for many of you as far as the designations, but we'll go through that a little bit today. And what you want to keep in mind is these designations may be affected by bylaws, future use or allocation of use of property, or amendments to how strata fees are allocated for the extended use of property. So for example, I quite often get questions from people saying, you know, this alteration is going to give somebody a larger share of property that they're going to have to live in. Can we charge higher strata fees as a result of that? That's a complicated question, and it may not be achieved just by granting the alteration approval. So that's something to keep in mind and consider in advance. Now, what are the property designations? This is kind of a refresher for many of you, I think. Let's start with common property. Generally speaking, it's the areas of the Strata Corporation that are shared for use or designated as the responsibility of the strata to maintain and repair. And examples of that would be building exteriors, interiors and hallways, lands and yardscaping, sometimes, parking and storage facilities, sometimes. With common property, what's really critical is to make sure, don't make any assumptions. Don't just assume because your neighboring building has common property parking area that it's the same for your building. You have to look at the strata plan, and you may need to get advice if it's complicated. There is a very technical definition of common property in the Strata Property Act, and sometimes it's important to consider that before moving forward. Now, it's also important to keep in mind that the Strata Corporation is not permitted to make an owner responsible for the repair and maintenance of common properties. So that's critical as well. If you're considering whether you're going to let an owner amend common property to build awnings or things like that, you want to think about how you're going to control that. It's not just a quick matter of them paying for everything. It's more complicated than that. Now next, limited common property. And that's common property that's allocated for the exclusive use of one or more strata lots. These could be balconies, decks, patios, yards or landing areas, parking spaces, or storage lockers. But remember, they may not be. So again, don't make any assumptions on that. You must look at the strata plan, and you also want to look at the strata plan general index to determine whether an area has been designated as limited common property. So maybe starts by, this is the opening part of things you want to consider, but don't walk past that because it's a very important step to make sure that you understand. So the other thing to keep in mind is that the bylaws of the strata corporation can be amended to define obligations of owners with respect to maintenance and repair of limited common property. So what that means is the strata corporation can have bylaws which are more complicated as far as making owners responsible to do things like clear snow from their limited common property areas or sweep them, or do other aspects that are more complicated and sometimes that are typically strata corporation costs. Okay, so if my townhouse backyard is limited common property, can the strata make me responsible for the maintenance of the trees and landscaping? So if we were all in person, I would say, what do you think? And I think I would be getting nods and shakes and various comments that maybe are corrected or maybe not. But in my opinion, because the trees and landscaping are part of the limited common property, yes, you can make them responsible, but you may not be able to do that through the standard bylaws. So if you look at the standard bylaws, they only require owners to conduct a custodial maintenance on limited common property. So that's like sweeping, cleaning, maybe clearing snow. But if you wanted to do something more complicated, you probably have to have a more specific bylaw related to that. Now, I have a quick story to tell you all about that process. So years ago, I was representing a strata corporation, and they had a bylaw that said that owners had to repair and maintain their limited common property decks. And because of that bylaw, over a period of 20 or 30 years, some owners were maintaining them in different ways than others. So there was one owner who was doing sort of a duct tape approach, not a complicated approach to maintaining strata, the decks. And there were various ways that people were maintaining them. The problem was that the strata corporation, of course, has a duty to repair and maintain the structure of the building. So in that scenario, there were a number of owners who didn't maintain and repair their decks to a standard that would have been preferable, and there was water ingress into the building. And so I tell that story as a cautionary tale. Just because you can make owners responsible to repair and maintain limited common property doesn't mean you should. Okay, so next slide, please. What are the boundaries of a strata lot? So the strata lot is those areas on the registered strata plan that are defined and shown on the strata plan. So in other words, if it's shown as a strata plan, it is a strata plan. It is a strata lot, I should say. And if it's not part of the strata lot, it's common property. So fairly simple, but the definition of common property is a little bit more complicated, as I mentioned. Before an owner alters a strata lot, they must obtain the written approval of the strata corporation. That's assuming that the strata corporation has the standard bylaws or something similar to the standard bylaws. However, if you don't have the standard bylaws, it could be different. So if you're here thinking about, I don't know what my bylaws say, it's a good idea after this session to take a look at your bylaws. They may need an update or they may not, but you want to have something similar to the standard bylaws, or maybe even more precise than what's in the standard bylaws. And the other thing to note about the standard bylaws is the strata corporation can't unreasonably withhold approval for alteration of a strata lot. And that's important because they are able to withhold approval of common property alterations under the standard bylaws, The Strata Corporation should consider that when they're determining whether to approve an alteration to a strata lot. Okay, altering a strata lot before you alter. So this is the standard bylaw 5, and it talks about the things that you have to get approval for under the standard bylaws in order to do alterations to strata lots. So you'll notice that there isn't anything under the strata bylaws, the standard bylaws, which say that you need approval for flooring alteration, or so you think maybe. But if you look down to G, and G is here in red, and that's a phrase that a lot of strata councils sort of walk past, and that talks about you have to get approval for those parts of the strata lot which the Strata Corporation must ensure under Section 149 of the Acts. So what does that mean? So the thing to bear in mind is Section 149 of the Strata Property Act lists the things that must be insured, and 149 sub 1 sub D includes fixtures installed by the owner developer. That's important because if you have carpet that is original carpet, that is a fixture installed by the owner developer in accordance with Regulation 9.1. So in other words, there are situations in which owners need to get consent to alter their flooring, even to pull up an old nasty carpet. But it could be more clear in the standard bylaws, it's not. So don't get tripped up on that. And as a strata corporation, if you wanted to alter your bylaws to more specifically clarify that owners have to always get consent before altering flooring, you could do that as well. Okay, next slide. Oh, we've got the slide up. Okay, obtain approval before altering a strata lot. So the Strata Corporation must not unreasonably hold its approval under subsection 1. So I talked a little bit about that before. The Strata Corporation has to consent to an alteration to a strata lot unless it would be unreasonable to do so. And so that's a different standard than than you have with common property, and it's important to keep that in mind. But more importantly, the Strata Corporation is entitled to require the owner to take responsibility for any expenses relating to the alteration. So I mentioned earlier that I really like to draft alteration agreements and I enjoy it. So a couple of the things that I like to see in those kind of alteration agreements, first you want the owner to pay for all the costs. So that's going to be the cost to do the alteration, of course, the cost to obtain permits and all of those sorts of things. But if you're getting a lawyer to draft the agreement, you also want to get the owner to pay for that cost to draft it. You may have, your strata managers may have, or you may have a standard agreement that you use over and over again. And in that case, you may not need a lawyer to look over it. But if it's a complicated or different agreement, you may want to get some advice, particularly if you're looking at alterations that may require permits or alterations that may involve structural issues. The kinds of provisions that you might want to see in there is the involvement of an engineer, for example. And you also, and I want to stress this so people will remember it, you want to make sure that the owner has ensured that the contractor who's performing the work is registered and in good standing with WorkSafe BC. Because if they're not, that cost can come back on the Strata Corporation, and it's there are quite a number of strata corporations who've suffered from that. So that's a key reason why you want to get the owner responsible for signing that alteration agreement. Now, in the red down at the bottom of that slide, we talk about bare land strata corporations that have adopted bylaws or retained building schemes or covenants that may limit or restrict development and construction. I have been involved with many of these strata corporations. Quite often they are related to aesthetics, and so quite often they're related to only certain paint colors and things like that for bare land strata lots. But I've actually been involved with quite a number of strata corporations that incorporate in their bylaws the obligation to comply with the building scheme. And the reason I think that's beneficial is, as a strata corporation, if an owner fails to comply with the building scheme, you have the ability now to fine the owner for breach of a bylaw. which gives you a little bit more ability to enforce those kinds of things if they're important to the strata corporation. Okay, who's conducting the alteration? So that's an important question as well. The standard bylaws only permit an owner to make an application for alteration of a strata lot. So quite often we see, let's say Mr. X is the person who's always at the elevator, he's the person who's in the parking lot, he's the one who drives the Mercedes, we know him. But actually Mr. X he lives in the lot, but he's married to the owner. And so for strata corporations, when they're looking at granting consent to alterations, they need to make sure that they're dealing with the actual owner of the property. So best case scenario, strata corporation does a title search. And if they're entering into an agreement with the owner, they want to make sure that the names on the agreement are all of the registered owners and using their names. So maybe they go by Mary and Bob, but maybe their names are Robert and Meredith. You want to make sure you use their full legal names as they appear on the title search. Now, commercial leaseholders with a registered interest in the property, they may have the authority to apply for alterations. Under the lease agreement, they may have that authority. That doesn't mean that the strata corporation has to deal with them directly. They can involve the tenant as well, and they may want to get the tenant to agree to the same terms of the alteration agreement as the owner. But it's really important to make sure that the owner's involved in that agreement as well, because if something goes wrong, the strata corporation wants to make sure they can go back against the owner and the tenant. But for bylaw enforcement purposes, going after the owner is critical because you have more flexibility as far as what you can do against an owner versus what you can do against a tenant. Okay, does every alteration need permits? I quite often get calls from strata council members who are saying, you know, this owner says, well, I don't need any permits, and his contractor says they don't need any permits. Is he right? So I'm not an expert on permitting, and I'm not an expert on every municipal law. So what I always do, always do, is phone the municipality and determine what requirements there are. I actually had a situation about a couple of months ago where I had a strata corporation that called me and said, this owner has turned their parking garage, or part of their parking garage, into a yoga studio. And is that okay? Do they need a permit? Because the contractor says they don't need a permit. They haven't removed any walls. They haven't done anything with common property. The first thing I did was I phoned the city of Vancouver, which was where the property was, because I know the city of Vancouver is quite passionate about parking and preserving parking. And I said, can they alter their parking without a permit? And sure enough, it came back that they cannot do that. So bottom line is just contact the city if you don't know. Not everybody can be expected to know everything about every municipality. Okay, so what do you want to watch for though are changes in plumbing systems, electrical structures such as doors, windows, walls, soundproofing, fire safety, systems, ventilation. The other thing to keep in mind is that, and I've seen this happen in my career, I think 3 times, and in all 3 of those occasions, there was an owner on one of the middle floors who removed a structural wall, so a load-bearing wall, and the owner above suffered significantly because the owner above their floor was sinking. So it's really important for strata corporations to try to prevent that from happening in the first place and make sure they know what they're consenting to before they do. Okay, next slide. Okay, how do we know if an alteration is significant in use or appearance? We've got some examples here of what is a change in experience. So if an owner wants to enclose a balcony, wants to install a skylight, or wants to paint their unit a different color, there are different treatments for that. So in my opinion, if they want to enclose a balcony, that's probably a significant change in appearance. If they want to paint their unit a different color, probably not a significant change. And the other thing is, there are quite a number of factors that the BC Supreme Court has determined as factors to consider whether something is a significant change. And that's based on the case of Foley and Strata Plan VR 3837. So it's a number of factors to ask questions about, is this significant? So first question is it visible to residents or members of the public? So in the case of closing a balcony, it may be visible to residents or members of the public. Installing a skylight, maybe not. It may be just the roof. Painting the unit a different color, not at all. So that's the first question. And the other question is, does it affect the use or enjoyment of other units? So for example, if the alteration, for example, blocked somebody's view of the ocean or a forest, that's going to significantly interfere with their use and enjoyment of their own unit. Another question to ask is whether it impacts the marketability of the unit. So for example, if I put a luxurious rooftop patio up on my unit and it's more appealing, it may make my unit more marketable. And that's going to determine whether it's a significant change. And the other question is, how has the Strata Corporation been operating in the past? So if, for example, every other strata lot also has changes to their balcony, which were approved over the years, it's arguably not a significant change if somebody else is requesting the identical change. Now, as far as the significant change issues are considered, the Civil Resolution Tribunal has considered a number of these applications. What I do when I advise owners and strata councils is, if you have to, err on the side of caution. If you don't know it's significant, but there are some factors to suggest that it may be significant, you're probably better off to require a 3/4 vote under Section 71 of the Strata Property Act than not, because if it was a significant change and you as a council consented to it, you could be in trouble with the CRT for having done that. Okay, next slide. Okay, title of this slide is I want to enclose my balcony. So in this case, a letter is submitted to council requesting permission to enclose the balcony of Unit 202. The strata plan and bylaws are reviewed. The balcony area is limited common property. Alterations are permitted that do not significantly affect use, enjoyment, or appearance of the building. So before the strata considers proceeding, they respond to the owner requesting the technical details of what is being proposed. And I agree. That's a good thing to do. In many of those situations, I would also recommend involving an engineer as well to give an opinion on that. In this case, the Strata Corporation is not obligated to grant permission for the alteration to common or limited common property. And yes, I agree. So the owner has a responsibility to get consent from the Strata Corporation. Strata Corporation does not have an obligation to grant it, but they may under certain situations and conditions. Okay, what are the critical questions? So an owner approaches the Strata Council for permission to alter their strata lot or limited common property or common property. The Strata Council needs to ask these important questions. Who will conduct the work? So do they know the name of the contractor? Is the contractor supervised by an engineer? Are they registered with WorkSafe BC? How will it affect the appearance of the building? Is it just a painting situation or cabinet situation? Or is it something that's going to interfere with somebody's view of the ocean, as we said? So will it affect any other owner? And that comes back again to the view. If the enclosure is permitted under zoning. So a couple of months ago, I was dealing with the Strata Corporation, and they had this rather unique problem. Maybe it wasn't unique, but it's the first time I'd seen it. They had quite a number of balcony enclosures, and it was a number of, I think they had 25 balcony enclosures. Some of the owners had gotten consent from the Strata Corporation, and some of them had not. And so as it turned out though, the floor space ratio for the building was such that only 5 of those balconies had a right to be enclosed as far as the municipality was concerned. So Strata Corporation had this very unique problem where they couldn't enable all of the owners to keep their enclosed balconies, and they had to decide who was going to have the right to keep them and not. So that kind of thing, zoning is really preferable to consider before the Strata Corporation is consenting to those kind of changes. Because if they'd known about the floor space ratio before they started consenting, they probably would have included bylaws and other things to ensure that owners understood the complicated nature of that particular building. So the next question is who will be responsible for the cost of the maintenance and repair of the enclosure? What happens if the owner sells? Will the alteration affect the building envelope? And will the city issue a building permit for the work? So quite often with these balcony enclosure issues, the only time that the Strata Corporation really considers them is later, long after they've been done, now that they're sort of decrepit and falling down, and the Strata Corporation now realizes that they need to do a building envelope repair, and they're trying to figure out how they can approach these enclosures. So what I suggest to Strata Corporations is before you agree to the enclosure, make sure you consider all of those factors. Make sure that you have an agreement in place, and make sure it's clear as far as who has the responsibility to repair, maintain, refurbish, and replace. Next slide, please. Okay, who pays for it all? The balcony application. As a condition of granting permission, the Strata Corporation may require an owner to pay for all of the current and future costs relating to an alteration. So they may, I think they should. I think it would be a rare situation in which a Strata Corporation would take any responsibility for that alteration. So yes, they should. The owner should be responsible for all of it. And an owner who's given permission to alter a strata lot is required under the bylaws to maintain and repair the strata lot. This includes any alterations, betterments, and improvements to the strata lot. Now, having the alteration agreement in place with the owner is important, and as I mentioned before, it's important to make sure the agreement is actually with the registered owner of the owner or owners of the strata lot at the time that the agreement is entered into. But also, it's important to make sure that there's a provision that requires any future owner to also be responsible to do those repairs. And what you want to do is make sure you've got a provision in that agreement that requires the seller, when they sell, the owner has to make sure that the subsequent buyer enters into a similar agreement with the Strata Corporation. Okay, what costs can an owner be expected to cover? And in red here, I see everything. I agree with everything. So permitting and engineering, additional insurance, that's important. Legal agreements, and as I said before, I think that an owner should give a retainer to the law firm who's drafting the legal agreements to make sure that the Strata Corporation doesn't end up having to foot any portion of that bill. Also construction, waste management and removal. So a lot of Strata Corporations have bylaws, for example, that say you have to remove any construction waste and not put it in the Strata Corporation's disposal containers. So you just want to reiterate that in the agreement. If you don't have such a bylaw, even more important to make sure that it's in the agreement. Any environmental costs, of course, you want to have the owner responsible for, and damages caused by the permitted alteration. So, for example, construction crews, if they're coming through and they're dragging mud or things over the carpets, you want to make sure that the owner is going to be responsible for those damages. Okay, unusual conditions to watch for. So sections. Strata Corporation may have multiple sections related to residential and non-residential strata lots, and they may have varied interests and uses. So in addition to the bylaws of a section, the bylaws of the Strata Corporation still apply. So in this scenario where you've got sections, you need to look at the bylaws for each section and determine who's responsible, which entity is responsible for that alteration. It may be, and it's actually pretty common, then owners have a duty to get consent from both the section, maybe the residential section or the applicable section, and from the strata corporation. And so all of those entities potentially need to be working together to ensure that they're complementing each other and that the agreement is signed in a manner that's consistent with the bylaws. Now, airspace parcels, and this is one of the things I really enjoy about my job is reviewing, I guess because I'm a nerd, I enjoy reviewing these airspace parcel agreements, and I spend a lot of time reviewing them. They're complicated, and it's kind of like a puzzle for me. But airspace parcels can be relevant to alteration agreements as well. So you need to understand what area of the strata plan you're talking about, or it may not even be part of the strata plan. It may be part of an airspace parcel that's owned and managed by another entity. So airspace parcels can be complicated, and in my experience, it's wise for strata corporations, particularly new strata corporations that don't necessarily understand the property rights within the strata plan, to get a legal opinion talking about who's responsible for what and how cost sharing can be arranged. Because I've worked with strata corporations that have airspace parcel agreements that haven't been implemented in 20 years. And it's hard to go back and say, well, this person should have been contributing to our costs and never was. So that's all I have to say about airspace parcels. Now, unusual conditions to watch for. So if an owner has an alteration agreement with the strata corporation, that they will pay for any costs related to a skylight that was permitted, does this obligation transfer to a new owner? Hopefully, but that's not an easy question. So a strata corporation should take as many steps as they can to make sure that kind of obligation transfers. So first, having the alteration agreement. Second, making sure that alteration agreement obligates the person who signed the contract to ensure that a new buyer enters into another contract, similar contract with the strata corporation. And also, the Form B information certificate requires the strata corporation to attach a copy of that alteration agreement when the new buyer requests an information certificate with respect to the strata lot. So best case scenario, yes, you have a decent argument to say that the new owner is responsible for that. But I do think there is, that could be more clearly set out in the legislation, and it's not. So I think strata corporations need to go in with eyes wide open, and if they're consenting to things like skylights, you have to be aware that they may not be able to enforce that against a future owner. Tony, did you want to comment on that at all?
Yeah, no, it's one of the most complicated problems that we have, though, because there's no central registry for alteration agreements, which is an issue that we've had with land titles in government for quite some time, hoping that there should be some way, either through the common sheet or the general index, to somehow establish a registry. It would certainly make these a lot better. And it would ensure that there's some sort of registry that would secure that these would run with the title. And so, because I think the biggest challenge most strata corporations have, and it's in one of our questions actually, is that they just have a really bad inventory of all of the alteration agreements, and nobody has any record of them. And so even with all of the good intent with all of this, it's a bit of a challenge for strata corporations, because they've passed through 5 or 6 management companies, or they've been through 10 or 15 strata councils, and they haven't maintained a central registry on a website or anything else for all these agreements. So even if they do this, oftentimes they don't even have the records to support them. So it is one of the biggest challenges for stratas when they're dealing with alterations.
It is, yeah, and I quite often get the question, can we register it on title? And no, there's no way to do it right now, but ideally that would change in future. Now, the green question, does the roof area that is common property change its designation because a skylight was permitted? And in my opinion, no, it doesn't change its designation. It's still common property. I know there are some strata corporations that say that windows and skylights are common property, but they're not, although the standard bylaws do set out that the Strata Corporation has the duty to repair and maintain windows and skylights. So that's sort of where some of the confusion comes about. Okay, special accommodations. Owners frequently make applications for alterations that relate to health and safety requirements. So the Strata Corporation is required to accommodate requests under the BC Human Rights Code. The one where I see this most often is air conditioners. And that's owners who are saying they've got some kind of medical requirement that requires them to have an air conditioner in their unit. That can be quite a controversial issue because other owners may be concerned about noise or the capacity of the electrical system to manage air conditioners. So it can be controversial, but this is correct that the Strata Corporation has a duty to accommodate. So if the person is able to prove that they have a disability, including a medical issue that requires them to have an air conditioner, for example, the Strata Corporation has a duty to accommodate that. Now, I dealt with one recently where the Strata Corporation consented to the air conditioner. They don't allow anybody else to have air conditioners. And what they did was they ensured that the agreement with the owner required that they would remove the air conditioner if at any time they sold the property. So they did get a limited right to have an air conditioner, but they couldn't pass that benefit onto a purchaser. Okay, review the information guide and webinar on accommodations on the BC Human Rights Code when managing requests for alterations relating to these conditions. The other thing I just wanted to mention about these kind of requests is that the Strata Corporation is entitled to get to request and receive medical evidence confirming that the person does have a medical issue. That letter should specifically say, in the case of an air conditioner, for example, that an air conditioner is medically required. It's not acceptable just to say that it would be beneficial, and that's the case law has said that. Okay, a new owner has removed 2 walls on their strata lot without permission. This has resulted in a change to electrical, plumbing, and the structure of the building. What is the obligation of the Strata Corporation? And I see bylaw enforcement. Yes, I agree with that. But what is, this is a very common scenario. And as I mentioned earlier, I've been involved with Strata corporations that have had sinking floors as a result of alterations to the structure. In this scenario, Strata Corporation has a duty to first enforce their bylaw. So the bylaw required the owner to get consent from the Strata Corporation before doing that work. So the Strata Corporation should be enforcing their bylaws. And in addition, it's important to remember that the Strata Corporation has the duty to repair and maintain the structure of a strata lot under the standard bylaws. So they may have more to do than just bylaw enforcement. They may have to go in and actually repair the structure. Okay, unauthorized alterations. Issue notice of a bylaw complaint regarding an unauthorized alteration, permitting the owner the opportunity to respond in writing or request a hearing. So that's going to be under Section 135 of the Strata Property Act. And then issue notice to inspect the strata lot and request all technical information relating to the change. Request copies of permits and plans and any certified documents. So again, this comes back to permits. It's quite possible that the owner did this kind of work without a permit, and if there was an agreement in place, the Strata Corporation would have been able to ensure that the owner would be fully responsible for that. If there's not an agreement in place, you've still got the ability to enforce it against the owners. Okay, unauthorized alterations. So if the owner fails to satisfy the requirements of the Strata Corporation and comply with the bylaws, issue notice of fines, issue a notice of application to the Civil Resolution Tribunal. So it's important to keep in mind under Section 112 of the Strata Property Act that the Strata Corporation has to give notice to the owner of the fact that that money is going to be claimed from them before they start the Civil Resolution Tribunal application. And then in the application, you're going to seek an order for damages, costs, and restoration of the strata lot.
I was going to say, Jennifer, the other thing that comes up here that we forgot to add is that if there is a structural change that requires permitting, that the municipality may actually issue an order ordering the repairs and the restoration, and make sure if you're the Strata Corporation, the order includes the Strata lot and the corporation, so that if the owner fails to comply, the corporation can actually do the repairs and charge the cost back to the owner, which, as it turns out, becomes a lienable cost, which is really quite compelling in some of these cases.
Yes, agreed. Yeah.
Wow, and we're down to questions. That's great. That's a great outline. It's a great kind of basics and primer. So so I have grouped a number of questions for you, and we kind of covered some of them, but they do kind of get into a broader scope. But in the Q&A stuff, for older complexes, this is a chronic problem where there's been all kinds of alterations to property that have occurred over 30 years. And as the person says, it's a checkerboard of common areas and strata lots and areas that are in between units. And what's happened is that there's a really bad case of property creep where people have pushed their fences out to gain more backyard space, or they've made bigger decks and patios and balconies, or put awnings in, or there's storage sheds. All these things have happened. And the problem is, you know, after all these years, is there anything the Strata can do to start to clamp down on these?
Yeah, so this is a question that I get all the time, and there are quite a number of CRT applications related to this issue as well. So I had the benefit of having this question a couple of minutes before this seminar. So I sort of put my mind to it in the way I used to do it in law school. There are a number of options. So the first option is do nothing, just let it be what it is. I don't see that as a particularly helpful or valid option, but that is one thing that a lot of strata corporations do. But the second option, which is the one that I prefer, is to go to these owners who have participated in the property creep and say to them, okay, you can have this space. We're going to have to call it limited common property. You have to pay for all of the costs to make sure to hold a meeting and get this approved, to register it properly in the land title office, to get a land surveyor, to prepare the documentation to show it as limited common property. And then you can have a bylaw that makes sure that they're responsible to repair and maintain that limited common property area as well. The third option is to take the common property back if they don't agree to the limited common property option. So what I think is the best scenario, and maybe this is my own personal approach, probably designating it as limited common property is preferable if you can get everybody to agree to do that.
Yeah, and you've just answered about 20 of the questions that are up on the Q&A, so but it also goes to the other issue, though, which falls under a number of these other questions. So what about, we're in an older building, we haven't upgraded our windows yet, but over the years we've allowed owners, or owners have just upgraded their windows to double or triple pane, partly because they wanted better efficiencies, but also because they were selling and they wanted to do an upgrade to their unit. We didn't necessarily get alteration agreements, even though the windows are common property. But what do we do about that now that we're going to be replacing all the windows in our strata?
Yeah, I get that question a lot too. And what I always say to strata corporations is, you know, for the owners who did it early, great for them. They may not want new windows, and they may opt out of having their windows redone if they can show that the windows are safe and appropriate, and that they're consistent with the building and what the owners want. But they can't opt out of participating in the special levy that may be required in order to do that window replacement. Yeah,
and that's always the $1,000,000 question. People say, well, I paid $1,800 for my windows. Can you just reduce that off my special levy? And they're forgetting that this is a common expense, and you can't change the formula on common expenses.
That's right. That's right. So ideally, in a perfect world, when the owner spent that $1,500 or $3,000 to put their windows in the first place, you would have told them, or the strata corporation would have told them, but so that you know you're still going to be responsible when the strata corporation does this work. But that doesn't always happen. Although I should say that there's something in here about dealing with neighbors and not wanting to be unfriendly with neighbors and creating friction. I, as a lawyer have no problem being the one telling people that they have to pay more money, and that's what the Strata Property Act involves. So for strata corporations, if they're dealing with neighbors and they want to be friendly and they want to be kind and respectful, they can just say, this is what our lawyer says, talk to our lawyer.
Absolutely, absolutely, and most importantly, but the other question, that one of the other questions we have feeds back to the whole issue of balcony enclosures, and I know people like to enclose their balconies because it can be, you know, through the winter it can be better, but it also gives them more space, and forgetting that this increases their FSR, their floor space ratio, that there is a limit on the number of balconies. But on newer buildings or buildings that have been remediated, it's often not even permitted because it may void the warranty anyhow, which is another great problem that we have. So, you know, as we go through that, an owner wants to, as a request, to put in to their strata, their air conditioning into their unit, and it's going to require a compressor on their balcony. Their balcony is enclosed, has a full wall between their unit and the neighboring balcony, but the strata is still insisting that they have to go to a 3/4 vote to the AGM. Is this really a significant change that's going to need a 3/4 vote? It won't be visible to anybody. It's separated by a wall from a neighbor. You know, I think probably need more details, but you know, if you apply the test, this is where we get into this real fine line that all the strata corporations go through. What's a significant change that needs a 3/4 vote?
Right, and I suspect that the council took that position probably because they didn't want to have to make an unpopular decision. I'm not satisfied that it's a significant change based on the description. It's not visible to anybody. The only impact that I can think of that might be on an owner would be a neighboring owner for noise from the strata, from the air conditioner. It's probably not a significant change. What do you think about that?
Yeah, no, I don't think it's significant either. Although one of the we've seen a number of these alterations that have balcony-mounted compressors, and it's not just the compressor though that's always raised flags for us. It's the penetrations that go through the wall for the ventilation that are a bigger problem, because we've seen some really nasty building envelope problems as a result of these not being put in properly.
Yes,
and that's a bigger problem. Yeah.
Yeah, I should say that doesn't obligate the strata council to give consent to the air conditioner. It just means that the question of whether it's significant and requiring a 3/4 vote may not be there. But I think the strata council should be open to saying no, especially if it's a common property alteration.
Yeah, no, it certainly has a lot of issues that arise that people don't think about at the time. So, and they are noisy. There is noise produced from them. But again, depending on, you know, what generation of air conditioner and compressor you have, there are some modern systems that are incredibly luxurious with virtually no noise, and they've figured out how to deal with the airflow penetration problems without putting the buildings at risk. So, you know, there are good options out there. They're just not inexpensive options.
Yes.
Okay. So then this goes back to an earlier discussion, but at what level of alteration should we really be asking for a building permit to be taken out? And you already went through that. You know, anything that deals with structure, electrical, plumbing, increase of floor of FSR, those basic issues. But we are running into problems, and I think this is where permitting is probably valuable. We are running into problems with older buildings that are being renovated or they're being upgraded. It might be an amalgamation of two strata lots into a single unit, or it may be a significant alteration. The challenge we're running into are the environmental problems, because the older units have asbestos in the drywall or in the spray ceiling. And so that's one of the, you know, contractors to get a job are happy to cut corners and say, oh no, you don't need a permit for that. But for the safety and protection of the people living in the unit and the neighboring units, a permit's going to flag that pretty quickly.
I totally agree. And so I think that it's important to, the strata council shouldn't have to guess whether a permit is required. And like I said, phoning the city is a good idea. But as far as asbestos is considered, I would suggest to older strata corporations, you need to get an opinion from an expert whether there's asbestos in the building now, so that you don't have to decide that at the time of each and every alteration, because I think it's very risky to be allowing alterations into older buildings that may have asbestos if you don't know if it does.
Absolutely, and I don't know about you, but we've been dealing with several strata corporations where we have people who like to flip units. You know, somebody just comes in, they want to renovate, they flip, they're gone, they've sold the unit. They do all kinds of unauthorized alterations, right? They remove walls, they put in kitchen islands, they change the plumbing, the drywall has been disrupted, they remove the popcorn ceiling. You know, they go through all this, you look at the age of the building and you say, how was this done? You know, and then of course the unit above starts sinking because they've removed a structural wall.
Right.
And then it's a nightmare for the strata corporation to try and recover from this.
Definitely, especially for these property flippers, because the person who caused the problem is now no longer in the building.
Yeah, they're gone, right? And that was the whole plan, was to do a quick renovation flip. And they're militant about pressuring their strata councils to give them permission for these things because they've invested with the mind of a profit here. They're taking a risk and they want a quick flip, but you know they're not giving any consideration to the impact or effect on all the other units.
Yeah. Right, and that's why I say, you know, I'm quite happy to be the bad guy amongst this community of neighbors who don't want to be jerks. I'm happy to be the jerk.
Yeah, no, exactly. It's one of the questions on the Q&A that I think is really helpful also. Who initiates a bylaw complaint with regard to an unauthorized alteration? Does it have to be an issue, an individual? Is it the strata corporation? You know, generally, if they get a complaint from an owner, that's fine. But if the strata corporation is aware of an if the strata council is aware of an unauthorized alteration, they can initiate the complaint.
For sure. I think that there are some councils who believe it has to come from outside the council, but a council member is an owner too. So a council member has the right to initiate a complaint.
Yeah, no, exactly. And well, and I think if they're aware of it, I think they might even have the duty to do it. So, yes. There's going to be a significant impact on a neighboring unit. Why are you not actually enforcing your bylaws? To which strata councils don't understand, if you don't do it and owners are affected, the owners can go to the CRT to get an order to force you to enforce your bylaws. So, you know.
Great. I think it's important for strata corporations to remember that the council has a duty to enforce the bylaws. They can't pick and choose what they're going to enforce or not.
Yeah, no, exactly. Townhouses, talking about townhouses for a sec. People like to take their attics and convert them into storage spaces or little offices or playrooms. So it's kind of like converting the parking garage in the townhouse into a yoga studio. They like to do the same to their attics. You know, but these have significant impact on fire safety and egress, ventilation in buildings. It's certain increase to the square footage of the unit. But these are things that they require consent to the corporation and permitting, definitely.
Yes, absolutely.
I just see where we're at with other questions. I think the last one that we'll do is not quite an alteration question, but it is fairly common in buildings that have hydronic heating systems that run throughout the building. And the question relates to heating of the strata building. So the strata corporation has a hot water heating system, runs throughout the building. They're all interconnected. The strata corporation, the owners now have heat valve issues and water flow issues within their units. And this is where it goes back to the definition of common property, that rather complicated Section 1 definition under the Act. This heating system is used in connection with all the strata lots, and it's capable of affecting all of the building system as it is part of a unified system. So how does the strata corporation, if they can, charge an owner for repairs to their thermostats and to their heating systems when they're all part of a connected system?
That is a complicated question. So the repairs to the heating systems, the argument under the definition of common property is that involves pipes, wires, cables, chutes, ducts, facilities for the passage of or provision of water or sewage, if it's used in connection with. So there's a line of case law, and there are quite a number of people who would take the position that any of these kinds of heating aspects are part of the overall use for the strata corporation. They're always going to be common property. I'm not sure that I completely buy that argument that they're always going to be common property, but I think there's an argument that it is, and if that is the suggestion, then the Strata Corporation, of course, has the duty to repair and maintain it. And how do you go after the owner? I don't know that you can. Right? What are you thinking as far as how you might claim that from an owner?
I don't know how you would, because it wouldn't fall under damages. It wouldn't fall under maintenance and repair because of the exclusion on common property, and it's defined as common property. I think it would be very difficult to do it, but I think it goes back to your cautionary tale also of be careful of what you actually want owners to maintain and repair or be responsible for, because no matter what happens, there will always be a group of owners who simply avoid their obligations, and the strata's left with all of the residual damages anyhow. And so it really, in the end, it's a false economy. Really, nobody benefits from it, and it does do things like, if it increases the risk of claims from water escape or those types of things, it does have a real impact on your insurance and any of those effects as well. So, I think it's incumbent on everyone to be careful about what you're really asking owners to do. I think that's the whole point of why we live in a strata anyhow. You live in a strata so that our collective building maintenance systems, security, our lifestyles, everything are collective and shared, and they're managed through one system. It doesn't do anyone benefits to download all of these things onto individual owners.
That's right. I've often questioned why that would be done in the first place. So as a strata lawyer, I've been doing it for so many years. Why you would ever, for example, cause owners to repair their own windows makes no sense to me. Just wait until it needs repair, and then everybody does it at the same time.
Or more ludicrously, the strata, it's an 8-floor mid-rise building, and yet the strata's adopted a bylaw that says owners have to wash their own windows. How is that possible? And we see bylaws like that, which means that the windows that are not accessible never get washed.
Yes.
And so there's rarely inspection and service on the building, and the buildings look dreary. And then the accessible windows may or may not get washed. And it may be a safety risk even for people to be on their ladders on their balconies trying to wash their accessible windows. So again, the impact of that is really inappropriate. So yeah. Thanks so much, Jennifer. That was brilliant. Good session, great session. We'll invite everybody, if you want to, these sessions are all posted to the CHOA website. The PowerPoint is posted to the CHOA website. Thanks to our principal funding partner for all the education programs that we do across the province, which is BC Housing. BC Housing just has a number of phenomenal programs and resources available, and we always direct everyone to go and look at the maintenance matters guides that are on the site. And thanks again to Steadfast Properties for sponsoring the event. And Jennifer, have a great day. Thanks again for joining us.
See you later.
Bye for now.